Thanks. So good evening, everyone. It's a real pleasure to be here with you. I have this thing around my neck because hopefully this is also recording for webinar. Is it working okay, or? Yeah. Okay, let me know. So as Jane mentioned, I work here in New York in the National ACLU Women's Rights Project office, and we do work around the country, but my focus for the last few years has been around this issue of gene patents as well as some other related issues. I'm going to talk about the genetic discrimination piece first, and then talk about our gene patents case. I also want to mention we've done some other advocacy around Medicaid coverage for male breast cancer survivors, and so that's another aspect of some of the issues around cancer that we've been focused on at the ACLU. Okay, so I'm going to start off with genetic discrimination, and I'm going to try to do a very brief overview of the legal rights that are available, as well as what's not available. And then I want to open it up to questions, and then I'll move on to a brief overview of the gene patents case for folks who are interested, to talk about how that case unfolded and just some of my perspectives on having worked on that case. It's a little cut off. Let's see. I don't know if that's just... All right. Well, sorry. The slideshow seems to be... It's a little cut off at the top. I don't know if... Yeah. No, it looks like it didn't really... Maybe it's just that slide, actually. All right. So, okay. Okay, so the Genetic Information Non-Discrimination Act of 2008, it was a landmark piece of legislation addressing discrimination based on genetic information, and it was the first federal law that prohibited genetic discrimination in health insurance as well as in employment. It did not address discrimination in other forms of insurance, so it does not apply to life insurance, disability insurance, long-term care, or other forms of insurance. So it is only applicable to those two contexts, and I think that's something that's important for people to remember. Is it not working? Okay. Oh, I think it's just, maybe it'll be okay from here on. We'll see. It might have just been my slides, actually. Okay. So what counts as genetic information for purposes of the law? What's covered is family medical history, so I think that's a really important piece. It's not just about what might be in your genes per se, but also what other medical conditions might be in your family, regardless of whether we know what the genetic connection is. What's also covered is genetic test results, so for yourself as well as family members. And what's interesting in the federal regulation is that they specifically mention BRCA1 and BRCA2 test results as genetic information that would trigger protection under GINA. What's also covered is if you request or you receive genetic services, so things like genetic counseling. The mere fact that you sought genetic counseling can't be the basis for an employer or a health insurer to discriminate against you. As well as participation in research studies. We know a lot of family members will participate in research studies looking at different genetic conditions, and so the fact that you've participated in those cannot be used against you. Now, what genetic information does not include is if you actually have a current health condition, what they call a manifested disease. So if you've actually already been diagnosed with breast cancer, that's not considered genetic information that's protected under GINA. That's an actual condition, and so we'll talk about that a little bit later. With respect to health insurance, what GINA prohibits is restricting enrollment or increasing premiums based on genetic information. So they can't, increase the cost of your insurance based on the fact that you have tested positive for a BRCA1 or 2, for example. The insurer cannot request or require genetic testing except for certain circumstances. So if you're already insured and you need to figure out whether you should get coverage for a certain procedure, where the diagnosis for getting that procedure is based on a genetic test result. In that kind of context, they could require you to get that genetic test, but in general, they cannot require you to get that kind of testing. And then the insurer cannot collect genetic information for deciding the underwriting on your policy or enrollment. But once you are enrolled, they can do so in those exceptions that I talked about if it's, for example, required to figure out whether a certain procedure should be covered. So a key thing is genetic information cannot be considered a pre-existing condition. So the fact that you've tested positive under a genetic test in of itself is not a pre-existing condition. But if you've already been diagnosed with a particular condition, that will be considered a manifestation of a disease, and GINA does not prohibit discrimination based on that. However, the Affordable Care Act, which was the health care reform law that's been in the news for many years now, prohibits the use of pre-existing conditions to deny enrollment in health insurance. So where GINA sort of stops, ACA steps in, but it does not yet go into effect for those of us over the age of 19 until January 1st. So right now it covers people under the age of 19, but once we hit January, it will now also prohibit discrimination based on pre-existing conditions. So that would include actually having been diagnosed with certain conditions. So GINA also applies to employment. Employers cannot classify or discriminate against employees based on genetic information. They can't share that genetic information. They cannot retaliate against an employee for asserting her GINA rights. So if you complain that GINA has been violated by your employer, the employer then can't take further action against you. And they cannot acquire genetic information except for certain limited circumstances. So they can't go out and try to figure out if you have a particular genetic predisposition. The way you enforce your rights under GINA is using the same legal procedures that are available under a federal law called Title VII. And so Title VII is the general federal civil rights law that prohibits discrimination based on things like race, on sex, on other protected classes. And now GINA was added under that. And so it applies where you have a state, local, or private employer with more than 15 employees. It won't apply if you have a smaller employer. So that is a gap in the protection of the law. And the first step is you file a complaint with the Equal Employment Opportunity Commission, which is also known as the EEOC. And that's the first step you take whenever you are filing any sort of complaint based on discrimination. So I just want to highlight a couple of examples of EEOC complaints so people have a sense of what's been done already. In the context of BRCA, one of the very first complaints that was filed under GINA was filed by a Connecticut woman who alleged that her employer fired her after she disclosed her BRCA positive test results. So she filed complaints with the EEOC and the Connecticut Commission on Human Rights and Opportunities, and so that's the State Employment Discrimination Commission. I've been trying to figure out what's happened with her case since that was filed in April 2010, and I haven't been able to find any follow-up to that, so I actually don't know how that case ended up or if it's still ongoing. A more recent case was a case against a company called Fabricut. And this was a temporary employee who was offered a permanent job. They then sent her to a medical examiner for a physical and a drug test. And so when she went for the physical, they asked her about her family history of heart disease, cancer, and other conditions. And they also found she had carpal tunnel syndrome. And at that point, they revoked her offer. And so if you remember, genetic information also includes things like family medical history. So she filed her GINA complaint, and the EEOC actually filed a lawsuit in her case after finding that there was reasonable cause to think that discrimination had occurred. And the basis for that is that there was this physical asking for this family history that was not relevant to whether or not she could perform her job. So they filed this lawsuit, they got a settlement, the monetary damages was $50,000, And they also made the employer agree to post various notices about your rights under GINA, as well as change their policies about how they ask employees to do physicals, and then training employees on these issues. So this is just a short chart I found from the EEOC that lists the number of complaints just to give people a sense of what's been happening. There have been about 200 complaints filed every year. The number seems to be increasing, and there are a variety of different outcomes. I think the most common outcome is that there is no cause found to think that discrimination occurred. So we don't know in every case why that was, but that's just something that people should be aware of, that most of these cases do not end up with a finding of discrimination. And then there, at the very bottom of the chart, there's actually a line about what kind of monetary settlements have been achieved. And so thus far, I think in the most year, the EEOC said about $2 million in damages have been agreed upon as a result of all of these complaints. And then the other thing I just wanted to mention, and the top law is the most important one, I think, right now, is the New York Civil Rights Law, and that governs what can be done once somebody has your biological sample. So New York law says that you cannot perform a genetic test on the biological sample without written informed consent. So even if your hospital has, you know, various samples that you may have provided in different contexts, you know, that testing can't be done unless you give written informed consent, and that includes in the research context. So there are provisions around how you have to agree for testing to be done on any samples you provide within the research context that either say that, you know, that kind of information needs to be anonymized, or there needs to be some other protections given to you in order not to connect the particular results to you as a person. Okay, so that was a really quick overview, and I guess I want to open it up now for questions on all of that. Yes?
I noticed there was nothing about discrimination in hiring.
Mm-hmm.
So once you're an employee, but can someone, if they find out about the results of a genetic test, not hire you? I mean, you had that test case in Connecticut.
Right. No, it would apply also for hiring. So you would not, they can't discriminate against you in hiring based on that information.
But an employer could not offer life insurance, right? An employer offers life insurance to all employees, and you tested positive. GINA doesn't cover you as far as life insurance.
Life insurance, yeah. Life insurance does not, it doesn't apply in the life insurance context.
So the employer could say, I'm not covering you, we're not going to offer you life insurance, and that would not be considered discriminatory?
You know, if I'd have to look further into that. If all of the employees are being offered that and you're being singled out based on the genetic information, I feel like that's more within the employment context and not just strictly in the life insurance context. So I'll have to look at that more specifically, because I think that there might be some arguments to be made there.
But it's really not clear on GINA that this GINA is really medical insurance.
It's in health insurance and employment, so this is sort of a hybrid. So that's why I'm not completely sure whether perhaps because it's in the employment context, you could argue that part of the terms of the employment should include that kind of coverage. Oh, sorry. Yep.
So under the Affordable Care Act, young adults can be on their parents' health insurance until the age of 26.
Right.
And from what I can gather, a lot of young people wait to be tested until 25 or thereabouts. So what happens, then they're going to go out into the insurance market. Is there anything that prevents them from being discriminated against when they then say, I'm BRCA positive and now I'm going to get my first insurance and I'm going, is premiums going to be higher, do you think? Is there any kind of protection against that?
Well, on the health insurance side, they are covered under GINA, right? So if they're getting tested and then they are seeking health insurance coverage, they are covered. They're protected from discrimination based on the fact that they've sought that genetic testing. Are you asking about other contexts, or?
No, that's pretty much it.
Okay.
I'm just trying to wrap my head around what happens if you learn at 25 when you're covered under your parents already, you know, and that's not a problem. But now you're going to find out, and now at 26 you're going to be out on your own. I just can imagine that if I was an insurer, I might say, I mean, it's kind of idiotic because the more you know, the more you can save costs down the road.
Right.
You know?
Right.
But you know, but they don't always see things as being idiotic.
Right. Yeah. So the question has to do with whether, as a young person at 25 and you've gotten tested, and I guess the idea is if you test positive and then you are seeking insurance outside of your parents' coverage, what problems are you going to face? And so GINA does protect you from health insurance discrimination in that context, but it does not apply to these other forms of insurance like life insurance or disability insurance. Yep.
As someone who is now Medicare, I am thinking going forward about tests. No physician has requested it for me. 15 years ago, I had early-stage breast cancer. So, you know, I am curious about it. And, but I wondered if there are any legal protections about the disclosure of that information as a result of the test. If I request it, or is it more advisable to have a physician?
If you request the test, or if your physician requests the test.
Whether it is more inclined to privacy if the physician requests it, as opposed to my requesting it.
Oh, I see. Well, so the question has to do with the privacy that applies. Sorry, I'm repeating it for the webinar folks. The privacy rights that may or may not apply if you ask for the test versus your physician asking for the test. That information is protected under HIPAA regardless of who seeks that information. And so in your case, you know, with any testing, for the most part, you're going to seek that through a physician. So whether you initiate that or, you know, your physician is the ultimate initiator, it will go through your physician. Is that what you're thinking, or no?
That's not what I mean.
Okay.
If my physician is not involved in it at this time.
Okay.
So if I go to, say, Sloan Kettering and request genetic testing at this point on my own, information, decisions, I'm wondering if that information is protected or if it will be disclosed. Do I have any control over it?
It's protected, so it's part of your medical record. So even though it may not be your general physician who's part of that process, you're going to be receiving genetic counseling or some other medical service through Sloan Kettering, and that will be part of your medical record. So it will have that same confidentiality as your other medical records do.
Is that recent? Because I know that there's a disclosure release that you have to, that is in the preliminary screening questionnaire.
Yeah, I mean, what GINA did is it did amend HIPAA so that law now specifically covers genetic information. So that coverage has been extended. Yep. Oh, yeah, I didn't.
Can you just talk again about disability insurance with GINA? Because I know I'm covered. I'm having surgery next month, and I've spoken with my HR manager. I know I'm covered through my health insurance, but where does the disability insurance then come into play? Is there a possibility that my boss will say, I'm not covering you for disability while you're out on your own? How does that kind of work?
Yeah, I mean, I think you should look at your policy to see what kinds of carve-outs, if any, there exist for these kinds of situations. So, you know, it really will be a policy by policy kind of analysis about what they might say about these situations, or maybe, you know, they won't treat this any differently from other situations. So it really varies.
It's sort of a blanket statement saying, you know, if you work with us for 2 years, you have full, you know, disability. There's nothing that says, you know, depending on what it is, for disability.
Mm-hmm. Well, I think that gives you, some comfort then, because they're extending that coverage broadly and they're not trying to, reserve certain exceptions for themselves. So, yeah. Mm-hmm. Yeah.
Two
Mm-hmm.
questions. One is on your question, and the other is on your question. The first part is there a group in New York, a legal group that would be best to go to if you feel you've been discriminated against? I mean, I know the EEOC, but if you have an upcoming surgery and you want a quick answer,
Mm-hmm.
I know there's a legal group, I can't remember the name of the legal group in New York, Randall Redkin, do you know Randall?
Mm-mm.
I just wondered who the best person or the best legal representation would be rather than just going to EEOC.
Mm-hmm. Mm-hmm.
Is there a group in New York? Does anyone in your group?
Yeah, so the question has to do with who should you go to if you have legal questions outside of the EEOC, and I do think that sometimes it makes sense to seek legal assistance rather than just going straight to the EEOC. The Cancer Legal Support Resource Center that was mentioned at the beginning, they're not based in New York, but they will do national consultations. They're based in LA, and maybe their information can be provided to folks at some point, like afterwards or something. But they're pretty easily findable on the web. We will take some intakes in our office, but I think that we're much more limited in terms of capacity on these issues. It's basically me that works on it. So, yeah, I think other than that, I know there's some private attorneys who will consult with folks, but I don't know of any other sort of nonprofit groups that do.
The New York Legal Assistance Group.
Mm-hmm.
I was thinking of, because I think it's specialized health related, and they're nonprofit.
They're a nonprofit, yeah. I'm not familiar with them having done work on the genetic discrimination issues, but possibly they have, yeah.
And the second part of the question is, I'd really like to understand exactly what is discrimination. So if we have this young person who's going out to buy insurance,
Mm-hmm.
and they've tested positive for BRCA, they can't be discriminated in that they can't refuse to offer them insurance,
Mm-hmm.
but can they charge them double the premium?
Yeah, no, GINA prohibits that kind of differential treatment as well. Mm-hmm. Okay, yep.
So if I understand this correctly, I don't have life insurance because I don't have any dependents. It's never been something that I've needed. If I were to now decide that for whatever reason I want to buy a small life insurance policy,
Mm-hmm.
and I were to be discriminated against because I carry a BRCA mutation,
Mm-hmm.
would the fact that I have had all the prophylactic surgery and my risk for disease is actually lower
Mm-hmm.
than that in the general population have any bearing on
Mm-hmm.
my ability to purchase life insurance?
Yeah, so the question had to do with life insurance and if you have tested positive but also sought all of the prophylactic surgery and so overall have a lower risk of cancer in the future, whether that should factor in terms of the life insurance policy purchase process. And I think, from the life insurer's perspective, they should be factoring that in. I can't speak to how they do that analysis and whether all of them are doing it. And it may be a process of education, but, a lot of what they base those decisions on are actuarial analyses where they're looking at people's, different percentages of things happening. And I think you're right that that is a valid point in terms of statistically what they should be thinking about. But I don't know whether all of them have yet incorporated that kind of thinking into the way they make their decisions. Yep.
If you have 85% of the people that are doing that test for ovarian and breast cancer, and they're coming back negative, and then you have the other 15%, because when I did the test, I was going through that, and it came back negative, it was great. I found it just for you. And I had other sisters, I did not know all that they, they had did the test back into and it came back negative. But then this year I was diagnosed with stage 2 breast cancer. So, I mean, what is being done about that? I mean, because I feel like I got cheated. And now I just did another part of this test that they offered me because I wanted to call the generic person. And I went and said, you know, how could this happen? They said, oh, it's fine, you know, but yeah, I still have stage 2 and I got to do all 3 processes. So I'm trying to really understand what is, you know, there's another part to the test, $3,000 for this test. So why was this all done at the beginning and we got 85% of the people coming back? Who's fighting this for?
Yeah, I mean, I think, yeah, well, I think you have every right to be. And, you know, I think some of the, I mean, the truth is genetic testing is not, it's not going to give you 100% of the answers as to your risk. And I don't know that that information is, you know, fully explained to folks. I mean, I'm a lawyer, so I don't feel totally comfortable talking about all this, but from what I've learned over the last several years, you know, I do think that the testing has been offered in different ways. It doesn't always include all of the known mutations, and that was a real concern of ours as part of the patent lawsuit. And then we also know that there are many other genes connected to breast and ovarian cancer risk that are not BRCA1 and 2. And, you know, a lot of the testing for those genes has not been made widely available. There are certain laboratories that are offering it, but it's not, I don't think it's really gotten out to the public the way BRCA1 and 2 has. So I totally feel for you because I think, you know, it's both been a problem with how the BRCA testing is offered, and then I think we need to make more progress in looking more broadly at the range of genes that might be connected to these diseases and make the testing more accessible to patients on all of those genes, because what patients care about is really knowing your risk of these diseases. You don't necessarily care about one gene versus another gene. You want to understand the full hereditary picture, and I don't think medical services now have yet been set up that way. Yep.
I have a question in reference to the GINA Act and employment in the workplace. Unlike other discriminatory practices in the workplace that are somewhat obvious, for example, I think I was discriminated against because I'm female or my age. The genetic stuff can be a little bit under the radar depending on how much you disclose. Is there an expectation in the legal world for a way in which you disclose this in order to say down the road I was discriminated against? In other words, I may have a manager that knows I had some procedures done because I disclosed to them I actually tested positive for the BRCA gene. I don't write it down. It's not an email. I don't tell HR. A year later, I get laid off. I think it's because I disclosed it, but it was a conversation. Is there an expectation that if you think you're ever going to be at risk for this in the workplace that you handle this a certain way? I guess I'm asking, is it better to sometimes overly communicate it as a means to protect yourself?
Right. I think different attorneys will give different advice on that. I mean, I think there would be some folks who, you know, depending on your employer, if it's an employer that has a practice of doing a lot of written communications, that might be something that people would advise you to do, because then it becomes part of your record and raises the question of whether it was based on this genetic information. And this is just a problem with employment in general. I think a lot of times actions are taken by employers and there may be, on their end, they can say there are multiple reasons, right, for that action being taken. And so it's always difficult for employees to prove discrimination regardless of what kind of discrimination it is. And so, yeah, I think there would be some attorneys that would advise that. But it's really a judgment call because you may not want to do that full disclosure to your employer depending on the circumstances. So yeah, I think it's something you would want to try to seek one-on-one counseling about, because I do think it really varies depending on the situation. Okay. Any other questions on the GINA piece? Okay, so if people think of more questions, we can also adjust them at the end. I'm going to just talk really briefly about the patent issue that we worked on. Okay, so has everyone here heard about the patent issue, or should I give some background on it? Okay, so we brought this case 4 years ago, challenging the patent office's policy of granting patents on genes, and the policy they had was to grant patents once the gene was isolated, and that just meant that it was removed from the rest of your genes in the cell. And so the problem with that is isolation is what everybody needs to do in order to test or examine the gene. So once you have the isolated gene, you've really locked up all the scientific and medical uses of that gene. So in the context of BRCA 1 and 2, it was Dr. Mary Claire King, who was then at Berkeley and now at University of Washington, who first found the link between BRCA1 and chromosome 17. And then a few years later, a company called Myriad Genetics, which is based in Utah, was the first to sequence it. So they were the first to figure out, all the code of those genes. And then a few years later, they obtained the patents on them, and they sent cease and desist letters to other laboratories that were already offering the BRCA genetic testing to patients based on the fact that they had gotten these patents. So BRCA 1 and 2 are just 2 of the genes that have been patented. There have been many others, and this is just a partial list. So, we became really concerned about this issue at the ACLU several years ago, and some of the concerns we had were around how gene patents interfered with diagnostic testing, both in terms of what cost would be charged for testing. Myriad had a monopoly on the testing as a result of its patents. So cost, how the testing was offered, which mutations were looked for, and so it goes back to the earlier question we had where Myriad standard test looked for most mutations, but then they have a separate test for an additional cost that looks for additional mutations on these genes that a lot of patients never get that separate test, and so that was of huge concern to us. And we were also concerned about the data sharing issues. So because they have a patent on the gene, they were really able to keep for themselves most of the data on these 2 genes. And unfortunately, within the scientific community, there's nothing that compels laboratories to share data. But when a bunch of different laboratories are doing testing, there's a huge incentive for them to share data because they're all getting little bits and pieces of the perspective on the genes. But when one laboratory has all of the data, they really have no incentive to share it. In fact, it's valuable for them not to share. And so that was of concern to us. And then we were also really concerned about the chilling effect on research. A lot of the scientists we spoke to told us that they were running up against the fact that Myriad determined what research they would allow and what research they did not think was legitimate research. And also the fact that there were all these new technologies that meant that inevitably you could sequence the whole genome, all 20,000 genes, at very low cost, and so the research efforts around that were being impeded by having patents on individual genes. So we filed a lawsuit on behalf of 20 plaintiffs, including some of the major organizations, a few researchers and clinicians, genetic counselors, and patients. And some of the clinicians are actually folks here in New York City. Wendy Chung is the director of the genetics lab at Columbia, and Harry Osher works at Montefiore, and then also Rich is a genetic counselor at NYU. And we were really lucky because we had an incredible group of experts and other advocates that supported us, including Force and other breast and ovarian cancer advocacy organizations, all the major medical associations, and we also had a really interesting brief filed by Dr. James Watson, who was one of the co-founders of DNA's double helix structure, and he wrote in his brief about how actually when he found the double helix, he was asked whether he would patent it and why he thought that was such an outrageous idea. And then years later, he was director of the Human Genome Project at NIH. And at that time, NIH was actually also seeking and obtaining gene patents. And so he resigned his position over that issue. And so that was about 20 years ago. So this is an issue that he's cared about for a really long time. Okay, so we filed the case 4 years ago here in federal court, and our main argument was under the Patent Act, which the Supreme Court had interpreted for many years to prohibit patents on products of nature. And so our argument was a fairly simple one. It was that genes are should be considered a product of nature, whether they're isolated or not. And so for that reason, they should not be patentable. We also made constitutional arguments because we were concerned about how locking up a gene locked up basic scientific knowledge versus patenting a drug, which is something that's been further transformed and others can develop another drug that treats that same condition. When you have a patent on the gene, you're locking up the basic thing, fundamental thing that you want scientists to work with and on. So in March of 2010, the district court judge agreed with us, and he invalidated all of the patent claims we challenged. Myriad then appealed that ruling, and it was a really significant step in that the U.S. government at that stage filed a brief agreeing with our argument that isolated genes should not be patent eligible. And so that was a big step because they were disagreeing with what the Patent Office had done, and of course they're all part of the same government. The appeals then reversed 2-1 what Judge Sweet had found, so we then appealed to the Supreme Court. And the Supreme Court at that time was deciding another patent case involving the Mayo Clinic. And so they invalidated those patents at issue in the Mayo case, and so they sent our case back to the Federal Circuit and said, oh, we're going to give you another chance to redecide this. But the Federal Circuit redecided it very much in the same way, and so we had to seek another petition with the Supreme Court. And the question we presented to the court was a pretty basic question: are human genes patentable? So I just included some photos. So this was actually the day of the oral argument, and there was a line, and it was also raining to get in. And some photos from actually Forrest and some other folks. Breast Cancer Action had a protest before the argument. And then I just wanted to give people a sense of the argument. So I think a lot of the press coverage of the argument focused on the fact that the justices really threw out a lot of analogies when they were talking about the case. And so they were really trying to grapple with, well, does isolation of the gene change it into something different, or is it still really your gene? And so Justice Alito was talking about, if you extracted a plant from the forest, would you be able to, and it was very therapeutically useful, would you be able to patent that? And so we were talking about whether, the fact that we thought you would not be able to patent the plant itself, but if it were further transformed and actually concentrated to have that therapeutic effect, that might be patentable. Justice Kagan talked about, whether this was just like cutting off a piece of the liver and then trying to patent that. Justice Sotomayor talked about whether what Myriad was trying to do was actually patent ingredients from a chocolate chip cookie versus patenting the cookie itself. So she was trying to distinguish the ingredients from the ultimate, what you might consider an invention. And then Justice Roberts talked about the baseball bat analogy, which is something that Myriad's attorneys have used throughout the case, where they were saying that what they had patented in the gene was like the baseball bat taken from the tree. And Justice Roberts replied that he thought it was more like just cutting off a branch from the tree and trying to patent the branch. So it was a really interesting discussion, I think, of really seeing how the justices were trying to grapple with what was at issue. And I think there was some commentary that questioned the use of analogies. I think a lot of law is about analogizing, so to me that made a lot of sense. And strategically in our case, we had thought really hard about what analogies we wanted to use. And so that was really exciting to see the justices engaged in that way. So in June, we got the decision, and it was a unanimous decision written by Justice Thomas. And he found that the isolated genes were not patentable under the Patent Act because they are a product of nature. And one of the quotes from the decision really adopted our argument in the case, and he said, Myriad did not create anything To be sure, it found an important and useful gene, but separating that gene from its surrounding genetic material is not an act of invention. And then there was another part of the case that dealt with complementary DNA or cDNA. And folks are interested in that. I can get into that. That's more of a technical issue, but the court found that cDNA is not a product of nature. cDNA. So cDNA is a form of DNA that does not contain the parts of DNA that do not code for the protein. So it's a more, yeah, it mirrors your naturally occurring mRNA, so it's very similar to what's in the body. And so what we argued is that also should be considered a product of nature. The court did not agree with us on that part, but we weren't troubled by that part of the decision because you don't need to use cDNA to do genetic testing. So the folks in the lab can do what they need to do in terms of testing without using cDNA, so they won't infringe on any existing patents. But it's a much more technical part of the decision that has been sort of, I think people aren't that worried about, mostly because the court was really careful to say that they were not deciding whether cDNA is patentable under other patent law reasons. And so there's other patent cases out there that suggest that cDNA should not be patentable, but for other patent law reasons, not the product of nature reason. Okay. And then Justice Scalia wrote a really short but interesting concurrence that also got a lot of commentary, where he said, I'm unable to affirm those fine details of molecular biology on my own knowledge or even my own beliefs. So there's been a lot of commentary about what that means, whether he's saying he just doesn't understand the science, or if he's questioning, from a more other perspective, the science in general. So the same day the decision came out, the Patent Office issued preliminary guidance, and they acknowledged that the decision significantly changed their policy regarding nucleic acid-related technology. And they instructed their examiners to now reject product claims that are drawn to naturally occurring nucleic acids or fragments thereof, whether isolated or not. So that was an immediate change from the Patent Office. And also that same day, NIH Director Francis Collins issued a press statement where he talked about the decision being a victory for all those eagerly awaiting more individualized gene-based approaches to medical care. And NIH, I think, has really made a huge transformation, on this issue over the years. Like I said, 20 years ago, they were seeking these kinds of patents, and now they're very much opposed to these types of patents in terms of what their effect is on medical care. So also the same day of the decision, 5 laboratories announced they would immediately begin offering BRCA genetic testing. And some of those laboratories are now offering the testing. Most of them, I think all of them, are doing so at significantly lower cost than what Myriad currently offers. And some of them are also doing it so that they are testing other genes relating to breast and ovarian cancer risk beyond BRCA1 and 2 within the same test. The other legal developments that have happened since the decision is that there have been a few lawsuits to try to clarify what Myriad's other patent claims, what effect they have, because we challenged certain patent claims in our lawsuits, the ones that they really were asserting against the other laboratories, but there were some that we did not challenge, and Myriad is trying to use those patent claims against 2 of the companies that began offering testing, Myriad Genetics and Gene by Gene. And so that's a lawsuit that's pending right now in the District of Utah. And then some other genetic testing companies filed lawsuits against Myriad, seeking to have their other patent claims either declared invalid or to have a court say what you want to do in terms of testing will not infringe on these other patent claims. And so the really big development there is that one of those companies is Quest Diagnostics, which is the biggest diagnostics company in the U.S. So they've already said that they are planning to offer the testing, and I think they want this legal clarity to figure out whether they'll have any liability for doing that. Okay, so that was yeah, the brief overview of that. Yep. Uh-huh.
Prostate testing, you have other diagnostic organizations offering the test. Would that become then competitive pricing?
Yeah, I mean, that's the hope, right? So I think, you know, Ambry is offering the test, I think it's standard test for $2,400. Gene by Gene is offering it for less than $1,000. So, you know, I think there's going to be, and I'm not sure what if Quest has said how much they are going to be charging for it. And then there's another company called GeneDX that's also charging less. I don't, yeah. I feel like maybe genetic counselors have developed that, but I don't list. I know that a lot of the genetic centers now are ordering testing from some of the alternative labs, so I'm sure that those lists have been developed, but I don't have that.
Regarding the subject, that some are higher priced and some are lower priced. Does it mean that the higher price are more reliable and accurate?
Mm-hmm.
Or better? Does it work like that, or does it work like that?
Yeah, no, I mean, I think, you know, I think it's something you should talk about with your, you know, genetics professional who's ordering the test, but that's not been a concern. I think. Mm-hmm. Mm-hmm. Yeah, yeah. Right, and I think you should consult with folks because, like I said, some of the companies are offering the testing in different ways, coupled with other genes, and then there are certain, you know, mutations that are not covered by certain testing methods. So it's something that should be discussed. But I do think the cost has been artificially inflated up to this point because there's been a monopoly.
My understanding is that the collective statistical information along the way, while they have not really on the genetic testing, have they been required to share that information, or have they shown any willingness to share that information with the other testing laboratories, or are they still holding it close?
Yeah, as far as I know, they're still holding it close. And so, you know, from this point on, of course, there will be more laboratories doing the testing, and so there'll be more data out there. There has been an advocacy effort from a geneticist at UCSF where he's trying to have, for example, genetic counselors share the results in one other database. So it's almost like trying to set up an alternative database because, of course, Myriad has all the data because they've done the testing, but then everybody who's received their test results also has those data, right? So there's an effort underway to try to collect all of that in an alternative database. But yeah, I mean, I think, you know, the fact that they have all that data does give them an advantage right now. And, you know, it's something that I know a lot of genetic counselors are talking about in terms of when that advantage actually is medically significant and when it's not. Because a lot of times with results, a lot of mutations are now well understood and well characterized. So it's not necessary to have, that's already out there. So I think their database is more important for very unusual or rare variants that are not yet really well known. Yeah. Yes, so it is part of the preventive services that need to be covered. So that is an important piece for people to be aware of. I think there's a lot of debate now, though, in terms of under what circumstances does it get covered, right? So it has to be covered, but I think there are going to be different criteria for patients in terms of whether you will qualify as one of the patients for whom it's covered. Some of it is looking at whether you've been personally diagnosed with cancer or if you're relying on or if you're seeking the testing just because you have family history. And so there's been that distinction made within the federal programs for a long time and in Medicare. And so I think there's still a process of figuring that out, but it is covered. It's just a question of whether you will be one of those patients for whom it's covered. Okay. All right. Any other questions? Okay, great. Well, I'm going to stick around for a few more minutes if people wanted to talk. It was a pleasure to you all. Thank you.